I did an 11-page article, or our firm did, about how to get $110 a day penalties for the plan not providing you with documents. Under 29 USC 1132C, the beneficiary might get up to $110 a day if the plan doesn't provide you with everything. How do you get those? Well, find out who the plan administrator is, and that's usually set out in the SPD, or the summary plan description. Write a letter to the summary, or to the plan administrator, but also write it to any other entity involved. The employer, the HR department, the third-party administrator, and ask for everything you can think of. You want the summary plan description, the plan document, which is the full version of the document, the health plan. You want the Form 5500 I talked about that they file with the Department of Labor and IRS. That discusses the funding requirements. Ask for the material modifications of the plan. Those are the things that change the plan each year that may change the language to adapt to case law. Also, I ask for these things, and it's not well defined anywhere, but I do it anyway because there's a provision of the code that allows you to ask for all relevant documents. Ask for the claims file, for any doctor's reports, any doctors that might have reviewed the claim as to medical care. Ask for the provisions of their plan policy, their claims handling manual. That's something that most people don't ask for. But if the claims handling manual has a provision on how they adjust a personal injury lien, you're entitled to it, and they won't ever give that to you. But in federal court, I've gotten that. If you get that in federal court and they haven't given it to you when you ask the letter, you can seek $110 a day. I was looking, someone was asking a question about how do you supplement, if they won't give that to you. Did you see that question, Gary? We can address the questions later, but let's look at penalties for failure to produce plan documents. In this case that I handled years ago.
Am I on the right screen slides, Phil? Is this where you want to be?
That works, yeah, it's discussing penalties, so.
Thank you.
Sure, thank you. Deezer versus Continental Casualty was a disability claim against this company, but I allege penalties for not producing the plan. If you look at it, Senior Judge Limbaugh, who was one of the most conservative judges, well respected but not good on an ERISA case, he ended up awarding us penalties for 441 days when they didn't produce everything I demanded. And to set up a plan like that, you need to have your client send the letter certified mail, and also send it first class mail, and send it fax if possible. But don't have your letterhead on it, and don't have your envelope on with the letter in it. Have the client take it to the post office so they don't know who they're dealing with. When that happens, they're more likely to withhold some of the documents, setting up your claim for penalties. In this case, I had the client do that 3 times, spread out over the course of a couple of years. So I came up with many days of penalties, but unfortunately, Judge Limbaugh didn't award $110 a day, so it was more difficult to get the full thing. Also,
the next slide yet, or are you still good on this one?
I want to tell you a little bit on Deezer and other cases. Attorney's fees are awarded in ERISA cases. So if a plan sues your client, they're entitled to get attorney's fees against a client. This case is instructive on attorney's fees because I did a long brief on what's allowable, and he awarded us attorney's fees. But the plan could obtain that against your client if you don't pay a self-funded lien. Okay, so let's go to the next one, Gary. This part, the health plans, tips, and strategies to reduce liens. Like I said, you have to determine whether the plan is self-funded through the general assets of the employer. Form 5500 helps tell you that. ERISA preempts state law, and the savings law clause, what that means, that saves the state law, state regulations from preemption. Excuse me, I need to click off something. So a self-funded benefit plan's not an insurance company and not subject to state law. They're subject to ERISA law. Next slide. We went through most of that, but what I want to say is when you go to the provision of the Form 5500, it's difficult to tell sometimes if they're self-funded or if they're fully insured because they'll check both boxes on the Form 5500. So under 9A, if they check insurance and they check general assets of sponsor, how do you know if it's self-funded or not? Well, then you have to look at the exhibits that are attached, the attachments listing each particular plan for the employer. They can insure like what's called a stop loss policy, a health or dental plan, or they may have the health plan self-funded. So you have to dig a little deeper because it's not quite as easy as just getting the Form 5500. Get all attachments and see which one's really self-funded. Okay, going on to the next slide. We talked about this briefly in the beginning where I said, what is ERISA? And I said there were a couple of exemptions to ERISA. If the plan is a church plan, a religious or government plan, ERISA doesn't apply. The problem is when you send your certified letter, or your client does, and you get the plan, it often says they're an ERISA self-funded plan and that all of the subrogation and reimbursement provisions of the plan apply. So you have to, again, dig a little deeper. And I discovered this the hard way in this case that I cite that's currently going on, Patton versus Cigna Insurance in St. Luke's. It's not a lien case, but if it was asserted by that company, all of these principles would apply. In this case, I was merely trying to get the plan documents from Cigna, and I had to write St. Luke's because they were the plan sponsor. I kept writing them these certified letters, having the client send them, and they wouldn't send me the stuff. So eventually I wrote a letter saying, you're subject to $50,000 in penalties for not providing me with this. And I got a letter from Lewis Rice saying, oh, we're not an ERISA plan, we're exempt from that. So I got the corporate bylaws from the Secretary of State. In this corporate bylaws, it says they're a religious organization set up for the delivery of health care. So if you get the corporate bylaws and it says they're religious, argue that they're like a church plan and that they aren't subject to ERISA. That's what I did. So then I sued them for vexatious refusal to pay under state law because ERISA didn't preempt state law. They denied my client's claim. If they come after your client, a hospital, and they're somehow funded by a religious organization or they're set up that way, then you would have the rights to allege bad faith against them and defenses under state law. If you were in Missouri and the Sisters of St. Mercy, I think that might be the case Gary mentioned, it's in his material. We're an anti-subrogation and reimbursement state. So the courts in Missouri don't favor liens on personal injury cases. So therefore, if it's a religious hospital plan, ERISA doesn't apply. There's an exception to that if they exempt into ERISA. So you have to find out, did they agree to accept the benefits of ERISA? because what I found in an Ascension case is, even though they were a religious plan, they filed a document that Greensfelder helped them with to say, oh, we're going to opt into ERISA. Let's go to the next page, please. Okay, we already covered that. We can move on from that. Now, number 3 is, this is really getting to the heart of things, because in the it wasn't a hypothetical, but in the case I discussed earlier, where the Meta colleague called me, they'd settled their case. It was a substantial injury. I don't remember the specific amounts, but he'd already received the settlement funds. They weren't in his trust account, and he paid them out to the client.
Hey, Phil, look at that. Look what I did with my little thing there. Pretty fancy, huh?
Oh, that's really neat. That helps kind of highlight this portion.
This is called high tech. My handwriting is about as good as this. Sorry.
That's awesome. Well, in the case we were discussing, there was no reimbursement agreement. And so really the attorney like us, we wouldn't have the obligation to repay the plan. But if we haven't told the clients that they might get sued, there's always a possibility of an ethical complaint against us, or we might get sued by the plan anyway, like our MATA colleague's gonna have to face. So when that happens, you have to know what rights the plan has. And remember when I talked about the statute earlier, there was a provision about other equitable action or rights against someone. In this case, when you've paid out the funds, they can go after your client for equitable relief. And equitable relief can be broad ranging, but that McCutcheon, US Airways versus McCutcheon, talks about some of the equitable relief that can be brought to enforce such a claim. And, you know, this is something that we don't discover much or go through much in our personal injury practices. But equity, when we went to law school, there were legal rights, which are damages, and equity. Equity is things like constructive trust. It can be things like restitution, quantum meruit, things like that. And I know later in the slide, I discuss a little bit more about that, and I kind of give some ideas of what equity is. But basically, equitable liens to recover the proceeds are what they're trying to get. The equitable lien, though, doesn't apply to every asset the person might have. It only applies to identifiable and traceable amounts of money. So I put in there, what if you give the client the money and they've already spent the money on food, bills, consumer goods? Are those traceable? What if they're in a IRA or 401k or an Edward Jones account? What about that? Well, courts have generally held that if you have your funds tied up in an account of an investment, those are readily traceable. So the client's funds are subject to getting attached with a constructive trust, which is quote unquote an equitable remedy. But if they spent them on things like probably bills for their health care and things like that, it's not readily traceable. Now, if the funds are commingled with non-personal injury funds and spent on these things, it's unlikely that that can be traced, but it doesn't mean the plan won't try. In the case that my good friend is going to have to defend, he gave the client the money. The client spent lots of the money on bills and things, but there's also a fund of money that can be attached. So they're going to name all of them and see what they can get. So we have to understand that even though the client spends the money on things, it doesn't mean they won't sue them. And if they do win and there is a fund they can attach, they're likely to get all of their attorney's fees.
Bill,
So,
don't you want to handle this in the front end and avoid having to deal with this later? Or I'm sure you already said that. This is
no, I
if
didn't.
you mess up in the first instance. Is that fair?
Actually, I did not address that, but I always recommend knowing the law like we're discussing so you can get out in front of it and know this. When you first meet with them, you should ask for the plan and get these documents, even though you think, oh, it's just a simple rear ender. Well, it's not so simple if they come after the client on an ERISA case. So I like to obtain all that, find out, is it a self-funded plan? And if so, are they going to be able to recover it? Because if we have a small amount of insurance, it might not be worth pursuing. So in order to do that, I often call the carrier in advance and I talk to them about that. I call the plan and I say, hey, this case is a catastrophic case. There's only $50,000 in insurance. There's going to be lots of bills. And I'd like you to reduce this and see if they'll do that or not. If they won't, it might not be worth pursuing. So the other thing, this thing where I say, what about a surcharge? That's something relatively new, and somewhere in the materials I talk about Montanil and some other cases, and a surcharge is kind of it's an equitable relief where they say it's a penalty against someone under equity to kind of right the scales of justice. So if someone takes 100,000 and blows it, even though the plan says they're entitled to it, the court could impose a surcharge against the individual, and then they'd owe that, and they might be able to attach it other assets they have.
Can I ask another question, Phil?
Of course.
Let's say you do mess it up, or whatever. Can they go after the insurance company who, because I know like there's other friends of defense lawyers here, like Debbie Champion. Can they go after the insurance company? Can ERISA go after the insurance company, like in a medical lien or a lawyer lien, or can they not under ERISA?
I'm not sure which entity are you talking about, Gary?
Can the ERISA lien holder, let's say let's say the lawyer pays all the money to the client and they blow it or they do it. Can the ERISA lien holder, like Rawlings or something, can they go after the insurance company?
Oh, I see.
Who paid the money to your client?
They could have, if they've already done nothing till the end, that's going to be very hard to do. But what the self-funded plan ought to do is they should make that claim early on, just like us, where we're wanting to resolve these issues. They could impose a constructive trust on those funds by interpleading them into the case. And one of the cases that I didn't get it into the materials, but I found a case in Illinois because some of us work in Illinois, and that issue is kind of part of that case, and it's called Pike versus Premier Transportation and Warehousing. I can provide that later. But in that case, what happened was there was a jury trial of a trucking case, and unfortunately, it was a defense verdict, but the lien holder, the self-funded plan carpenters union, which have very strong rights.
They're the toughest.
They had a plan that required the reimbursement agreement I talked about. They made the plaintiff sign that or they wouldn't pay benefits. So they paid $161,000 in benefits. That was paid out, and then it was a defense verdict. But what had happened was they entered into a high-low agreement, so even if they lost the case, they'd get a sum of money. Well, that health plan intervened in the case, and they asserted the right to a constructive trust on any proceeds. And that Pike versus Premier case, it basically said, because they signed a reimbursement agreement the ERISA plan carpenters union gets everything and the client gets nothing, and there's no allocation for attorney's fees. So the client's left with nothing, and so is the firm that tried that jury trial. So yes, they can go against the insurer. They could have gotten that.
Can they go against the attorney's fees? Steve Bernstein posted a question.
Yeah, so attorney's fees.
And I don't mean to derail you on your presentation.
No,
so.
not at all, but there's limited time and I have a lot of material in here. Somewhere on the proceeds, I have what's called the common fund doctrine. And in the common fund doctrine, I'm not sure what slide that is, but the common fund doctrine means if you create a pot of money and you're the one collecting the money for this self-funded plan or Medicare, Medicaid, shouldn't you get credit for attorney's fees and expenses? And that question turns on what state and circuit you're in. If you're in an ERISA context where it's a self-funded plan, the 8th Circuit doesn't allow the common fund doctrine, but the 7th Circuit over in Illinois, it does honor the common fund doctrine, and they actually passed a statute saying that subrogation is allowable in ERISA and even state law cases, but they're going to give credit for all attorney's fees and expenses. So knowing that, if you're in the 8th Circuit, they can get the whole thing and you get no credit for fees or expenses. Illinois is different. You get to reduce the lien by the amount of fees and expenses it took to collect the money unless they sign a reimbursement agreement. Does that make sense, Gary?
Yes, it does.
Okay.
All right, I'm going to go to your next slide.
Yeah, we were talking about equitable relief. I just cite a case here because this is a good case where if you look it up, there was a subrogation and reimbursement provision, and there were 2 insurers in this case, and the court applied the reimbursement provision differently. And in one of them, they allowed subrogation reimbursement of the self-funded lien, and the other one they didn't. And it's important to understand that the plan, even though it says the reimbursement agreements apply, if it doesn't identify a specific fund of money that their reimbursement applies to, it's not enforceable. So in that case, one of them said something like, we shall be reimbursed the full amount of your medical expenses out of any third-party recovery, and the other one didn't have that language. The one with the vague, ambiguous language wasn't enforceable. So even though we think we know the law, you can find cases like this Poplawski case that help us. It's 11th Circuit, but you could use that to challenge your plan's reimbursement agreement and say it fails because it's vague. If we go on, I think I cite some more cases that are worth talking about. Not sure which slide's next, Gary. Okay, that one, Saraboff versus Mid-Atlantic Medical Services. That's a good one to know about because it's a suit for equitable relief by the plan against a policyholder for benefits for a lien and a PI case. And basically it talks about you have to have an identifiable fund of money to collect on. And the plaintiff, if they don't have that money where it's identifiable, they can't collect. Also, let's see if we go, yeah, I didn't cite this, but Great West versus Knutson, that was the seminal case on this topic where you have to be able to trace money to specific property, and if you commingle it, it's not necessarily enforceable. This make-whole doctrine is kind of like what we talked about the reduction for attorney's fees and expenses. Illinois allows that, but Missouri doesn't. Also, if we go down there, let's see. Looking down at subpoint A, I say Eighth Circuit case, Walmart case. That's another example. That's one, if you may recall, a big personal injury firm, well respected in St. Louis, got a huge verdict against Walmart, and the plan came after the client for $500,000. The personal injury attorney that was a specialized attorney paid it all out, not knowing it was a self-funded plan. And that's a nightmare. That client would likely have sued the law firm for malpractice by not resolving that at the beginning. And that's why Gary and I like to resolve our liens at the beginning and address it on the front end. Because if you don't know it, you're subject to getting sued. Now, the firm raised such a stink with the media and everyone got so outraged. Walmart, for public policy, waived that $500,000. So the firm was okay and the client was okay. We've kind of discussed that, and we're running short, so let's scroll through this. We did the common fund, that was the attorney's fees. Now, how do we use equity on our side as a sword or something to fight the insurer? Latches or unclean hands, that's kind of a nebulous concept that we discussed in law school, but an example would be you litigate the case, they know you're litigating it, they've never raised a lien on your case, they've never asserted the constructive trust, and then you get all the money, you pay it out, your client has to use it on bills, then they come after them. Well, remember, latches means that if the plaintiff or the plan in this case sits back on their hands and does nothing, they're kind of guilty of unclean hands. So you could allege that, saying they should have raised that at the first possible instance, and by not doing so, you're prejudiced. Down below, the failure to produce the documents and can be a breach of fiduciary duty. I do that in every single case, and I always raise penalties. So I can't stress it enough. Doing the letter like the guide to ERISA penalties, how to get $110 a day on our website. Part of it's in the materials, but there's more on our website. You have to do that and send it out so you can raise that against them to offset the lien. We can go on, Gary. Equitable relief we discussed. Montanil is another seminal case you ought to read. That's a very good one in this area. Then I discussed the concepts a little better. I try to set out equity and what that means. You can raise that against the insurer just as they can raise it against you. If they don't pay out your plan benefits to your client, why not seek a surcharge against them for not paying everything? I'm doing that in some breach of fiduciary duty cases. Hasn't been ruled on, but I'm going to ask for money against the plan for not upholding their obligations under the plan. So basically, in conclusion, I've ran through, a lot of material faster than I wanted to. It's a very convoluted and complex area. So I've included the plan language. We won't have time to go through that, but at the end, I include all the language in that first case I talked about where one of our colleagues is getting sued for $150,000. And you'll note in one of those documents that Gary has cooperation there. Cooperation is required in every insurance policy to cooperate with the insurer or the plan administrator. If you don't cooperate, your client doesn't cooperate, they're going to claim that you didn't preserve a fund for their benefit. They will try to claim it against the attorney and get some equitable relief like a surcharge. So that's very important to study this language. Know if your plan has it so you or your client doesn't get sued. If they have this, address it at the first stage of the proceedings and try to negotiate the lien off the front end.
So even if they're going to assert contract language and stuff, and say, you have to pay back because of the case law you cited here and in the prepared paper, we can still go use equity to fight against those rights like we would in any other lien.
You sure can, but the problem is it's circuit by circuit. That's easier to do in Illinois. Missouri and the Eighth Circuit are not as good for employees. I still try to do it anyway, and many insurers will do, or plans will reduce their liens if you talk to them early on. But if you sit back and wait till the end and they know you got that money, there's no incentive for them to reduce it.
Right. Because, and you use the lien, I guess you would use the same negotiating tactics you use for other liens, saying, you guys can try to take all this money, but my client ain't going to sign the release. It ain't going to settle the case unless you play ball here.
You can do that. And then, some things you can do. I didn't get into this too much, but I attend these reptile seminars with Don Keenan.
What's the reptile? I've never heard of that. I don't know what you're talking about.
We sign a confidentiality where we can't go into too much about it. However, like Debbie Champion would know about it. I think she does contrary seminars.
No idea.
So basically, in a PI case, if you present damages of pain and suffering, change of lifestyle, future problems, but don't seek any money for past medical expenses, and you don't get any, there's an argument these liens, even though they're an ERISA lien, wouldn't apply. And if your pleadings are consistent with that, your settlement agreement says that, there's a good argument you don't have to repay them.
Let me ask you this too.
Sure.
I think I'm going through the chat questions.
Okay.
The other thing though, what about the idea that, so the people that you're negotiating with on the ERISA lien, it's with Rawlings or these other companies, they all get a percentage of what they settle. So everybody got to be reminded that they're incentivized to take a reduction and cut a deal with you to do it. That's my one point. And then the second point, Phil, is have you ever done an end run around the Rawlings or the people who are trying to collect to try to go to the plan administrator who may, like, let's say you have an employer who really likes the employee. Can you go around the Rawlings company, go to the plan administrator and say, listen, this is your lifelong employee. He's in a wheelchair. Cut your lien more, and get the plan administrator from the company that owns it to try to trump or to overrule the person who's trying to enforce the lien?
That's a good question, and yes, I have done that. And I think, like I mentioned, Anheuser-Busch, because I've represented hundreds of workers there. Many times they've given their life for 30 years or more working for the company, and the company values that. So if you can get to a person in charge, write them a letter, not Rawlings or someone, and then try to pick up the phone and call them and explain that. Sometimes they have compassion, and that's the one that makes a decision, not Rawlings. So it is good to do that.
Good. I got another question that comment. I'm sorry, Phil, did I overspeak you?
No, I'm done with that.
So there's another question, and I think you touched on this. What if they don't give you the documents? What if they don't give you the plan or the Form 550, or they don't tell you the plan administrator? You touched on it. You can use that equitably later, but what do? Keep sending them letters to show their bad course of conduct, or what do you do?
I keep sending them several letters so it looks really bad, but you can also file your own separate lawsuit for the documents and seek the penalties of $110 a day plus all of your attorney's fees. But I would keep that in the hip pocket, not file suit. When they come after you or your client, you raise that as a counterclaim if they bring a lawsuit or just in negotiation, to say, well, it's been a year, you owe me $110 a day, and my attorney's fees are at $450 or $500 an hour, so you're going to owe $100,000 on your $30,000 lien, so you better waive it. Does that make better sense?
That makes sense. I got another question, and then I think we're almost. I had another question. is it okay? Is it satisfactory just to ask for the documents from the third-party administrator, or do you have to go straight to the plan administrator or the person who's funding the plan?
The only way this penalty statute applies is to send the certified letter to the plan administrator. And I would point out that the TUI case, whoever that was against, I handled that case. They hid the plan administrator and it wasn't in the plan document. I got it in litigation finally, and it was some company we've never heard of in California. So my letters didn't apply to that. So you have to get the right plan administrator, send the letter to them, or penalties don't apply.
Got it. All right. Any last parting thoughts before we before we take a very short break and move to the next one, Phil?
I would just say this area, I know I've covered a lot. It is somewhat complex, but if you think of the penalty as a sword to go against them and the equitable claims, there are some things you can do against them. But if you argue early on for a reduction of the lien, that's the best approach, not just sitting back and ignoring it, because that subjects your client and you to a potential suit, and none of us want that.
All right. So folks, I have, that's it. That's all I got. Phil, thanks a lot for doing this. Very informative. I would also note, so in my experience, Phil's very open to answering questions too. So if anybody has a question, pick up the phone, call Phil, email him, that kind of stuff, and he'd be happy to help you, I know.
Definitely, happy to.
I'm going to let everybody take a 4-minute potty or coffee break, or whatever you'd like, and then we're going to go into my presentation. So I'm going to mute everything just for a minute. And
great.
Then we'll be back and ready to go. Thanks a lot, Phil. Great job.
Hey, thank you, Gary. It was an honor.
Yep. All right, everybody. Welcome back. Thanks, everybody, for coming again. So I'm going to start beginning our next hour of CLE on negotiating liens, negotiating and resolving liens. Y'all, if you didn't hear me in the beginning, remember that all proceeds of this are going to legal services. This is a time of need when folks even more need legal services help. So if anybody has any would care to support legal services financially even more, you're certainly invited to, and you all know how to do that. Great organization. Right now, so without further ado, everybody should have gotten an email from me this morning. We had a lot of late registrants. We're popping right up to the 100-person limit mark on this Zoom conference. So this is also all being recorded. Anybody can get this later. All the materials are available later, will be available on the website, and everybody was emailed those this morning. So, so I'm excited to start this. Let me get my PowerPoint ready to go here and share it with everybody. And so here we go. Thanks for, so here we go. So this is resolving liens in our cases. So liens truly are they're a huge part of any case, all right? And they become more and more. It used to be not as much, but now it's every case. And sometimes the level of the lien and where it is informs us as to whether or not the case is going to settle anyway. So, and as I go, but my one caveat here is I'm going to go fast. I got a lot to talk about. Sometimes I talk a little fast. I've been drinking coffee since early this morning. This is my Burger Law coffee mug. On the back of this, I have the definition of compensate. So I put that on. I think that may show backwards anyway. I use this to, anyway. But you know what I forgot to do? I forgot to put my phone number on the damn thing. So much for marketing, right? All right. So, so it's a huge part of any case. The defendant and the plaintiff want the liens completely resolved. The defendants do too. Sometimes the defendant resolving these liens are a hang up with the defendant. And what you want to do is you want to reduce the liens as much as possible. I tell my clients, I get as much for you on the front end of the case as well, but then I reduce the liens as much as I can on the back end to put as much in their pocket because that's what they care about. I'm literally talking to a client this morning. He wants to know what's going in his pocket. I can talk about 100 grand or this or much of this, but what's going in his pocket, that's what he wants to know. So that's really important. And what happens is people don't want to deal with liens. They don't want to handle it. So it's kind of like, it's like that old file you don't want to deal with. You put it in the corner and you don't want to deal with it, but you got to deal with these liens in the front end. And one of the things that happens is, especially if you have a ton of liens and they're complicated, you got some from insurance, you got some ERISA, you got a provider, you got this, you got Medicaid. You're like, I want to deal with it later. Do the opposite. Do the exact opposite. Take on the liens head on. Make a lien file in every one of your files. In our firm, the lien files are red files. Tackle them head on. Talk to them about the client ahead of time so that when you're trying to get them to take a number later, then if you want to then if you're trying to push them into getting a settlement later, you gotta say, remember, I've been talking to your liens for 6 months in this case. You know about that. You're apprised of that. Sometimes liens can change. So you go work on the lien holders. You've been talking to them for a long time, and then they know you've had an ongoing conversation so that it's not like you're calling them at the very end to try they get a surprise call. If you've been having a communication from the beginning, that's great. I settled a case recently, got a wrongful death approval. I had a $270,000 ERISA lien where I got them to reduce it to $80,000, which is still a lot of money to pay off out of a lien. But I had an ongoing conversation with the guy, and he figured I knew I wasn't BSing him. He knew I was being truth. And I said, listen, my client ain't going to sign a release if you don't make it worth her while. And this is how you do it. And I showed him the numbers, and he got it that I was being fair. So a lien is a notification that the debtor's holder is asserting an enforceable interest in the case. I already said reduce liens as much as possible. Remember, statutory requirements have to be perfected to have it to be a valid lien. Medical bills for which no lien asserted need not be paid. However, the way I look at that is I don't care whether or not they sent the lien by certified mail, because if I don't count it as a lien, they're going to come after my client afterwards and get the money afterwards. And what I do not want to have happen is I don't want to settle a case and then the client called me back 2 weeks later and said, I thought this was all gone away and now I'm getting sued for $5 grand for a chiropractor bill. And I can say, well, they didn't perfect the lien, blah, 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 blah. But you know what? That's not what the clients want. And in fact, I do it the other way, especially if I'm using the lien reduction statute. Because I can tell the clients, listen, as a service to you, part of my very eminently reasonable contingency fee, I'm also going to reduce these liens for you. And I've had cases where, you take a case with a policy limit and they got big bills, and as a selling point to get the case, I said, listen, I'm not going to get you more than the 50 or the 100 or whatever on this limit. But what I can do for you is I can use the lien reduction statute. I could negotiate the lien. So when you walk out of this thing, you're going to be in the best position you can, and these debts aren't going to follow you in the future. That used to be a selling point that people kind of listen to, but now with health insurance and stuff, that's a big selling point to even get a case in the front door. So I always do. So I always negotiate these things down. So in a settlement, in my settlement letter language, I always say no other medical bills are known to be outstanding, but I make sure that that's right. Sometimes the client will say, listen, I know I have this bill, and this bill, but only pay the liens, and I'll have those people chase me, which they can do. You have to listen to your client. And if that's the case, you need to put that in your settlement letter. So 6 months later, when you forget about this and they call you back, you can say, listen, I told you that you had these bills coming after you. We already told you this. And I say, or say certain medical bills are outstanding and they may remain your responsibility. And then when I settle the case, I tell the other lawyer that I will let the client protect, indemnify, and defend for all liens. And then the last thing, in a settlement, pay all liens. Do it. You don't want to have this come after you later. You don't want to have to deal with this later. You want, and we're very good at that. And then you get a reputation too. I mean, if you're a lawyer and the defense lawyer has had another case where the liens got all messed up or something, then they're not going to let you just protect and indemnify. They may cut separate checks to the lien holders. They may demand other things. So you want to have a reputation and a pattern and practice and a process in your firm of doing it the right way. All right, so here's some ethics issues on liens. So a lawyer cannot guarantee the payment of liens in a settlement. There's an Missouri Informal Opinion 125. I attached that as one of the appendices to my written materials. The client can, but the lawyer cannot. So look for that in the releases. So the client can agree to protect, indemnify, and defend against liens, but the lawyer cannot. And sometimes the other thing is, sometimes they'll put, so if they want the lawyer to sign the release, look to see what you're signing as a lawyer. What it should say is that you've reviewed as to form and content, not that you're obligating yourselves to those things. Illinois I looked this up a couple of years ago because I had this come up. It's very interesting. Illinois is even a little bit different, it's even a little stronger, they looked at Ethics Rule 1.15b, and they said that a lawyer representing a plaintiff has an actual obligation to segregate the settlement funds over which a third party has a claim, to notify them of that, and then distribute the funds owed to those people under 1.15b. So that gets a little thorny in terms of one of my other tactics on doing liens is, let's say I have a provider who won't negotiate a lien with me. One of my other little tricks is I say, fine. And they say, fine, are you paying it? And I say, no, fine. I'm going to leave it in my trust account for 6 months. And then in 6 months, let me see if you want to take the third off that I appropriately offered you. And then you'd be amazed what they'll take 6 months down the road of money sitting in your trust account. The amount that they would never take before, they'll take later. Well, I think I may be challenged in that practice by this rule 1.15b, but I do have to balance being fair to my client with being fair to the lien holders, and obviously my allegiances to my client. Now, if the lien holder's bill is really pretty reasonable and they're not overcharging, then it's probably not fair to me to really hammer them down a lot more. However, we all know the providers that charge $5,000 for an injection, or the chiropractor who sees someone, 6 times and has a $6,000 bill. So that's not fair. And so then that chiropractor has to agree to a reasonable amount, in my view. Let me see. All right. So that's the ethics side. Medical liens. So medical liens, they have to provide a formal written notice to the liability insurance company, not you as the plaintiff's lawyer. The lien under the Missouri revised statute, it goes to the liability insurance company. As well as in Illinois. That's why when the insurance company is always sitting there going, well, we need you to protect us from liens, that's why. It's because the lien, as well as the attorney fee lien, goes to them, and they're on the hook later. That's why I asked Phil that question in his presentation the last time about whether the ERISA lien goes to the liability insurance company or not. That's different. So that's the power of the medical lien. And in Missouri and Illinois are different in a very important way. In Missouri, if the medical provider provides a lien, then this is the statute. They get 50% of the net proceeds, and I'll do this more in a minute, after fees and expenses, and they can't collect anything more from your client. In Illinois, they do that, but they can collect later. They can sue you. In Illinois, they can sue your client later for the balance of those bills. So that's something to think about in settling and resolving liens. It's a way to do it differently in Illinois versus Missouri. So Liens can drastically affect the net settlement values. I already said that a couple times. Negotiate with the medical providers and the lien holders to minimize their share. If the bills have already been paid by a health insurance company and the medical provider is trying to get more money, they cannot. The medical provider has a contract with Blue Cross Blue Shield or GHP to accept a certain amount for the service, and they cannot overbill. They cannot balance bill, it's called. And I've had some cases in protecting some people about that. They're not allowed to do that. Now, there are, for years, St. Anthony's used to charge health insurance companies on a car wreck case, and as soon as they figured out it was a car wreck case, they'd pay back the insurance company and put a lien in your case to try to get more money from you. And there was actually a class action in Kansas City where they stopped some hospitals. There was a big verdict out of there. Some lawyers took that on. I always thought that was inappropriate as well. So and your client is the third-party beneficiary from a contract between their provider, their medical provider, and their health insurance company, not to charge more than that reduced rate. And that's a, I could talk more about that, but I don't want to bore you. So there you go. We talk about it. So remember, when we're talking to these insurance companies, these are not just arguments. These aren't just legal tricks or artifices that we're doing as lawyers to try to help our clients. It's the reality of the case. And if you have the power of the facts and the truth to back you up, when you call that provider and say, listen, you're a chiropractor. My ballpark used to be $100 a visit for a chiropractor visit, right? So if they go see him 20 grand, pay him $2,000. If they go see him 20 times, pay him $2,000. Pay him $3,000, but don't pay him $10,000. That is not a reasonable charge. And chiropractors are not going to get they're not going to get reimbursed at those rates from Medicare, Medicaid, health insurance companies. And just because they have someone with a PI case doesn't mean they can charge unreasonable amounts. So lien negotiation, how do you do it? Begin negotiating prior to the settlement. When the numbers are fluid and the defendant offer is still low, your negotiating position is strong. And so what I always do, let's say I have a case that I think is going to sell for 50 grand. And of course the first offer from the insurance company is $10,000. I always say, send me that in writing. And they're like, why, are you going to pay it? Are you going to accept it? No, I want it in writing. And when I get that first offer in writing, I send it to the client so that they know how tough the insurance company is. And the second thing is I send it to the lien holders. And I say, listen, they're only offering me 10 grand in this case. Are you kidding me? So that way, later on, they know I'm getting them a good deal. So negotiate it fluid, get them to take 50% off their bill, and then you go back to the defendant later and you get an extra 10, 20 grand to settle the case. It's not that you're not going to tell them that. It's not that you're going to hide the ball, but you get the lien holders to commit to a lower number when they think the numbers you're going to sell for are lower. That's why I really emphasize, and I know Phil said it too, that's why I emphasize do this early, do it early. Kind of like voting, do it early and do it often. But remember, you got to balance the amount of the charges, the quality of the service to the client, your integrity, and the size of the settlement and other factors. So if you've been doing this for a while, you also don't want to sit there and screw the provider every time, because we got to remember those providers provided a pretty good service to your client. Your client didn't have health insurance, and they went and they gave them PT, and they gave them an MRI, and they gave them injections. You can't screw that provider over. That would be inappropriate. I don't want to speak, but you got to be fair to that guy. So you call him up and you say, hey, Dr. So-and-so, what's a fair number? Or this is the deal. So, and if there are really good providers and good people, good medical providers, maybe you don't want to. Maybe you want to get them paid some good money, because your client may go back to them for another adjustment, another injection. You're going to have other clients down the road. That provider is not going to treat any of your people if every time they know you're calling them up and asking them to take 10 cents on the dollar. You can't do that. I already said this, I already did this one. The next point I have, I did let me get my little drawing thing. I did the first low offer to them. Here's another trick. Here's the other thing I do. So let's say you have a case, these are the two things, these are what we do. So let's say you have a case where they're going to, you know you're going to have to use the lien reduction statute. Well, what I want to do is I want all the bill providers to assert a lien. I want them to assert a lien in Missouri. That way I can use the lien reduction statute and do it. And then secondly, sometimes there's not people who do not assert a lien in the case. When that happens, I just tell them they did. I mean, not assert a lien, but I just say, listen, you're going to be treated like everybody else. I tell them that they have to take everything. They have to use the lien reduction statute, and they have to take what I say. I'm not being fair to them. I do a pro rata thing. I'm going to send you what I do. I have in your material you were sent, you have my Excel spreadsheets, and this is definitely worth the $25 price of admission here. The high cost is you got my Excel spreadsheets that my amazing paralegal Casey made a long time ago, where we have these spreadsheets where we calculate out the liens, and then we send those lien distribution sheets to the lien holders when we do the lien reduction stuff, because we say, here's all the liens, here's your pro rata share, here's this analysis under either Missouri statute or the Illinois statute. This is what you get. And I've never had a problem. I have never had a problem in doing this thousands of times. I've had a couple people complain, but not in that way. They've said, well, I didn't assert a lien or this or that. But I mean, but then I have to go to a motion to adjudicate lien. And by the time I notice it for hearing and I show up, they never show up. And I'm not being unfair to them. I'm using the power of the law to my client, but also I have a gut instinct and I kind of know what's a fair amount and what's not a fair amount for this provider to take. And I don't have any doctors who don't take my clients because they know that if I have medical in a case, if I have 10 or 15 grand in a medical case and I settle the case for 100 grand, I'm not going to ask anybody for a reduction. I'm going to fully pay them because I got enough money because the case warrants it. Because the next time when I have 10 or 15 grand in medical and I settle the case for 10, they're going to know why I had to do it. And I show them that stuff. So that's when I talk about using your integrity. When I talk about your integrity, use your integrity. Deal with the lien holders like you would anybody else, straightforward and transparent. So here's what I say. Most lien holders do not send by certified mail. So whether the lien holder is perfected may be in doubt, but who cares? I don't care because my client doesn't want to get sued later. And then this, savvy lien holders who can withdraw their lien or realize their lien was not perfected because they see a statutory thing coming, they try to do that. But I think it's part of my job, if that happens, to go into for a motion to adjudicate lien, because you have jurisdiction to do that in the case. You can do a motion to adjudicate lien and reduce that lien down, and you go argue it. And most judges will say, you got a bill provider, somebody come in and they're going to say, Judge, all I want this provider to do is take what everybody else took in this case and just the way it went. And you're going to win that 9 times out of 10. And 99 times out of 10, they're not going to show up to the hearing, or the day before the hearing, they're going to call you and say, okay, we're going to take your reduced amount. We're not going to hire a lawyer to do that. This is some other things on liens. This is continuation from the last slide. Different organizations have different styles regarding reducing bills. Some are easy and some are hard. Each one has different administrative protocols or hoops to jump through. You got to know what those are and who those are. If it's the carpenters union, you're in trouble. The carpenter union, I've talked to those people and they're really good because you get them on the phone and they say, listen, I'm not reducing my ERISA lien because every amount of money that I get from you is going to go pay the next carpenter who gets injured. And we have a pool of money and we're losing money in this because it's expensive to do. This is coming off the backs of these hardworking carpenters. So you know what? You got to pay us back 100%. And you know what? They're right. And in an equitable analysis, you know what? They're going to win. So you got to know who it is, okay? And if you know the provider who charges $5,000 for an injection and then reduces it later, you got to know that. And the problem is the defense lawyers do too. So going into it, if you're ever counseling your client about who to go to and who not to go to, don't go to those people, because the defense lawyers know who has unreasonable billing practices. And if I've been in a lot of depositions with a lot of providers, and they will cross the heck out of them. And then it looks like so anyway, think about that as you're going through. Get the bills as you're going through. If they are too unfair, leave the money in your trust account. This is the little trick I said earlier. If they're too unfair, leave the money in your trust account and leave your money in your trust account for 6 months, or adjudicate the lien with a motion to the court. Some lien holders ask you to or force you to provide information. Are you reducing your attorney fee? And they provide you the exact details of that. Well, those people, get ready, because those people are about to be real jerks to you, and they're trying to start a fight. Okay. And that means that don't ever send them another person. Not that I would ever suggest a client to go to any medical, because I know there's defense lawyers listening, but you know what, don't ever send them another case. Are you kidding me? If I have to like bare my soul and fight with you in 30 phone conversations just for you to only charge my client $200 every time they saw you, that's ridiculous. That's what I think. Be careful not to over-reduce or be unfair to medical providers because they have given a great service to your client. I already talked about that. Client expectations are an important factor in reduction negotiation. If a client has an expectation of a certain amount of money they will receive after attorney's fees and costs, reduction of bills and liens is a way to arrive there. If the defense lawyer is fighting you and won't go up another dime, and you're about to have to go spend money to take doctor's depositions, rather than fight that recalcitrant defense lawyer or insurance company anymore, go to the lien holders. Maybe if you could make up the money over on that side, you'd be surprised. And the other thing is, we do this all the time. Call and get the amount of the lien. You would be amazed. The attorney fee bill, the medical bill you got when you started the case, 6 months, a year later, you call them back. Maybe insurance paid a little bit more. Maybe they wrote some of it off. Maybe they can't find it. I can't tell you how many times we're getting ready to go to a mediation, or we're doing a billed versus paid, or getting ready to go to trial. We're calling to confirm balances on these things, and they change. And you also, maybe they're up. Maybe your client went and got more money, more stuff, and that may throw a wrench in the works. Or maybe you take that new lien where there's an extra $110,000 in medical, then you send that to that recalcitrant defense lawyer and say, hey, dude, my medical just went up. You got to pay me more. There's no way I'm going to take that. And that gives the defense lawyer ammunition to go to his adjuster and say, listen, you got to do this. Just like in anywhere else, do not overpromise and underperform on liens. Do the reverse. Underpromise and overperform. Your client is going to love you if you say you're going to get 20 grand in your pocket at the end of the settlement, and then you go reduce the liens a little bit more and they get $22,000. They love it because you're under-promising and over-performing, which is the exact opposite of that's what you want to do. That's what you want to do. And then they're happy and they think you're great. All right, reduction arguments. So here's the things I tell. So when I call the person at whoever the adjustment, when I call the secretary at the chiropractor's office, or when I talk to the whoever it is, and this also, these reduction arguments all go to ERISA negotiations as well. These are equitable arguments that you're using, that I use to try to get people to reduce liens. Sometimes successful, sometimes they're not. And the other thing is, here's the other thing is remember that as a lawyer, you don't want to have to do this every time. So what you want to do is you want to train your support staff to do this, and you want them to get it. You want them to understand this so they can call and do this for you. I have form letters that say these things, or I have different paralegals that call up and say, listen, and they do this. So you want to systematize this so you're not doing it every time. So let me go through my reduction arguments. Listen, if it was a health insurance company, you're only going to make 1/3 or 50% of the amount you charged us, right? So give us that reduction. You know that you're billing at at 150% on what you get reimbursed. So give us that. Your bill is not a true reflection of the value of the services. These are the types of things we would go through when we were doing all those depositions before DEC and the bill versus paid stuff, where we'd go try to figure out the reasonable value. Use the lien reduction statute. Listen, why don't you just cut your bill by this much? Because if you don't, I'm going to be forced to use the lien reduction statute and reduce everybody pro rata. But if you give me a little bit of break, I would do it. Here, it was a difficult case. The patient had to hire a lawyer to obtain the recovery, and the lien holder should pay us for that. The lien holder is effectively getting a collection attorney for free. So instead of having to hire Jay Umansky, who I know was on this, who does a great collection job, sometimes I get Jay's letters, and sometimes Jay helps me out in cases. So it's all good. Jay knows what he's doing. So they don't have to hire Jay. They effectively got me for my eminently reasonable fee. We'll take a third off of your bill because I went and got it for you. And then if they go, well, are you reducing your fee? Well, then you can say, listen, my fee would usually 40%, and I'm reducing it to a third, or or whatever. But you reducing your fee it's apples and oranges. And you say, well, I'm not reducing my fee. I have to deal with you. But you reducing your fee is not a function of what the value they're getting. They're getting a free collection lawyer. Tough liability. Our client is reducing his recovery because of that and is being undercompensated. Our client is not getting that much money. I've used this very successfully. You have a case with 100,000, you have a case with some limits, and your client's injuries are profound. You're saying, listen, dude, my client, it's $1 million case that we're taking $100,000 for. So why don't you reduce your bill to 10% of its value? Because that's what effectively my client is doing. That's the type of equity that we're talking about here. And sometimes that'll play to them, sometimes it doesn't. Then you say, listen, we're not going to sign the release if you have your thing that if you have it that much. Sometimes you could go into a motion to adjudicate lien, because that's the reality, if that's what's happening. Now, if that's what's happening, though, remember that you're ultimately going to do is use the lien reduction statute. Remember that don't waste your time. If you're going to end up using the lien reduction statute, don't waste your time in arguing to these people. Just use the lien reduction statute. Don't say anything to them. Other lien holders are reducing liens liability, difficult, caps on insurance recovery, caps on non-economic damages. Here's another one. I'm going to move fast. We're trying to get this settlement done and are calling all the lien holders to try to get them a reduction. No settlement, you're not going to get paid. Liability and health insurance, discount chiropractic medical care and evaluating cases. If these chiropractors think that they get paid by insurance companies for $200 or $300 a visit, I don't care how many adjustments or how many times you x-ray the person, that is not accurate. That doesn't happen. All right. Remember the Missouri lien statute. This has to be certified mail to the insurance company. It's the exclusive remedy for medical people to get out of the case. It's the only way they can pursue the tortfeasor or his insurer. Remember, and afterwards they can sue. They have a year to sue. They have a year to sue the insurance company if you did not pay them. They don't apply to wrongful death claims. Medical liens do not apply to wrongful death claims. I have put this, even this year, I have put this in court orders approving wrongful death cases, settlements in wrongful death cases, because if you're died, your debts die with you. So if your poor client dies, don't pay the medical, get the wrongful death claim, settle it, because they can't have a lien for the medical bills against the dead person. Remember that, please. And if anybody wants a form of the order or my motion for the wrongful death settlement, and I don't tell the lien holders that. They are sending liens to the family. They're doing this, that, and the other thing. We're not going to sit there and say we're about to get around that. No, because you don't have to open an estate in Missouri and Illinois. A lot of times you have to get a personal representative, but you can get a personal representative just for the wrongful death claim in Illinois. In Missouri, you don't have to open an estate. You don't have to let all the creditors go into the estate for this person. All right, let me keep going here. So this is what I call the lien cram down statute. This is the Missouri lien reduction statute. Basically, you take the total amount of the settlement, and I'm getting comments and I'm not looking, and I'm going to try to go through the comments. I'm going so quick and I can't see the comments on my screen. So I'm going to try to do these at the end in about 17 minutes if I can. If the liens exceed 50% of the amount of the settlement, every healthcare practitioner, they're limited to that. So what we do is you take the fees and the expenses out, and after that, the client gets half, and all the lien holders split the other half pro rata. And that's the way it works, all right? And then here's the key, and I've argued some motions, but I've always won them. Any healthcare provider electing to receive benefits under the lien, it releases the claimant from further liability on the cost of the services and treatment provided. That's a huge deal. That is present in Missouri and not in Illinois. So there you go. And we have form letters in our distribution. We tell the client what we did. We have form letters to all the providers. We cite these statutes specifically in the letters. We tell the providers what they're entitled to get. We give them the spreadsheet of what everybody got. We're totally transparent. We do it a lot. I mean, I hate to brag that my settlements are so low that I have to use the lien reduction statute. That's a joke. But sometimes you do, right? And you get that benefit. You get to give your client that benefit. And we have those. I shared a bunch of them in the appendix. All right, the Illinois statute is complicated, all right? Total liens can't be more than 40%. No single person gets a third. The total liens, if the total liens exceed 40%, professionals get 20% and providers get 20%. I don't know what that means, but I got an example for you. You have to reallocate this. This is all in the statute. If the liens are over 40%, your attorney's fee gets to reduce to 30%. So if you have a straight third fee on an auto crash case, you got to reduce your fee to 30%. It's statutory, you do it. I have in my screen, this is an example. Here's a $50,000 settlement, and you got to allocate between the doctors get 20% and the hospitals get 20%. So this is one example, and I could give you a lot of example. But then your fee went down to $15,000, which is fine. You lost $1,600, but it is what it is. But then the providers all get that, and then you got to remember, you got to tell your client, listen, in Illinois, they can go after you. They can come and sue you later. Now, hopefully, so that way in Illinois, you want to try to get them to agree to that amount, and you want to get them to not go after your client anymore. So if you could take that extra step and get an agreement with them, that is very beneficial to your client. All right, let me move now to health insurance liens. Health insurance liens are only through, and we already talked about it, you can't do it. It's against Missouri public policy. If it's not an ERISA plan, you can't assign a personal injury case. That's the logic behind Schweiss and other cases. But if it's a multi-state plan and not a single player plan, it's governed by ERISA. That's what Phil already talked about. This is from an old presentation. This is what I do for some things, steps I do for ERISA. You ask for the trustee plan. You want to get proof they're an ERISA plan. You have people saying they're ERISA plans when they're not, to try to get around that. If it's verified, negotiate it down with the same ethics lessons or the same logical arguments that I presented before. Have the client sign a proof of representation, or Medicare. So Medicare, in the written materials, we have the address, we have everything you do for Medicare. You get a conditional payment letter. It'll generate a letter. It does not need to be filled out, the rights and responsibilities. When the conditional payment is received, look at it, because a lot of times Medicare will put in treatment that's not related to the case. So you'll say, listen, we had a neck injury. He has all this, my client has all this heart-related treatment. It's not for this, or this is not about diabetes or whatever. So you want to talk to them, and they'll cut it out. They'll get it. It takes time though, especially with Medicare. Start early, get that conditional payment letter, because you don't want to settle a case and then start looking at Medicare, because it takes forever. It's going to take 6 months. And then you got to leave the money in your trust account and deal with that. And when a case settles, immediately submit a final settlement detail. This outlines attorney's fees, expenses, settlement amount, etc. Within 60 days of receiving this info, they should issue a final demand. We have a membership with Medicare, with CMS, where we can get into their portal and find out right away what the liens are and what the difference is. And that has helped in some mediations. Or you can call them and you can say, listen, I'm mediating this case tomorrow. I need to know what my lien is. And then you also, when they get a final demand and a final number, you also want to negotiate with them, because they will negotiate down too with you. You can't be unfair to them, but you got to say, listen, liability was tough, or look, your lien is, there's the same, you're just doing the numbers, the same arguments. Medicaid liens are very similar, a little bit different. You still get a conditional payment letter. You got to sign a HIPAA in, review the list of providers and to make sure that they're related to your case, because you could knock a lien down. The other thing is, look, on these liens, folks, if you settle this case and the defense lawyer refuses to pay you for the back surgery, then don't pay a lien for the back surgery. Yeah, did he get a back surgery after the car crash? Yeah, but you couldn't connect it up because he had the same herniated disc on an MRI 5 years before the car crash, and had PT visit for it the week before the car crash, So then you say, you can't get this paid out of the lien. Put it in the release. With when you release it, say, listen, the parties understand that they're not paying for, although everything's included, but the defendant took the position that I put this in the release to help me with the liens. And most lawyers will say, sure, if you want to stick something in the release saying that we took the very strong position that it wasn't related, that the back surgery wasn't related to the crash, then that's a good way for you to fight the lien. Same thing with Medicaid. They'll update this, etc. So same ideas on Medicaid as well. All right, let me go to my next slide. So let's go to work comp. So work comp, it's basically Rudiger or 287.150. They have a right to, if you have a comp civil case, the work comp have a right to have a strong lien in your civil case. It's the lien, it's determined by the formula set out in Rudiger. It does not apply to uninsured and underinsured claims. It does not apply to those. The rule of thumb is settle the work comp case first and then settle the civil case. Don't settle the civil case first. You want to know what your work comp lien is. It will make it very hard to settle your comp case. You need to make those decisions too about whether you want to make the comp case, because that all those providers are going to say that your client is totally fine and has 0% disability in your civil case. So that's something you want to always remember about whether it's worth it to do it. I typically, a lot of times I don't do it in auto cases. I say, listen, you're going to make more money in your auto case. Why fight for a $10,000 lump sum disability settlement at the end of the case when your injuries and when all your medical is going to hurt you? All the doctors are going to say you're totally fine. So just as a side note. All right. So here's the Rudiger formula. This is the handy, I always get confused on the math. So here's the handy dandy how to do Rudiger. The total amount of compensation, that's medical and lump sum disability payments and TTD, it's everything. Total amount in the civil case, you divide line 1 by 2, you subtract your fees and costs, write it there. Sometimes it's good to have a 40% fee, a higher fee in that. You're going to reduce the lien on Rudiger. So that's what that is, that formula. Here's a couple other issues with these work comp liens. An insolvent insurer cannot pursue a subrogation interest. There's cases on that. And we've had work comp people, insurance companies go insolvent. They can't do that. They can't get their money back. If your contract says that your expenses apply to both work comp and the civil claim, they're to be paid from the civil claim. So when you did this formula back here, if your expenses come out of the civil case here, that's going to reduce the work comp lien a little bit more, okay? Even if you were spending the money on a rating exam in the work comp case. Your contract says it applies in the civil case. What if you lose the work comp case? You're not going to get paid back for that rating exam. And certainly the doctor in the rating exam is also going to be one of your testifiers in the civil case. So there's nothing wrong with doing that at all. All right. I already said it includes the amount paid in medical. Spouse's loss of consortium claim can be protected from subrogation. So I know smart lawyers who have settled a case, put a lot of money into the subrogation claim for the wife and put a little bit money in the civil claim, and that's a way to avoid those bills. If you have back to the liens, you can do that on the liens too. Let's say your injured plaintiff has a huge amount of liens or a huge amount of ERISA lien. You're going to try to put that into a consortium claim. However, if it's an ERISA claim, you may have a little bit of unclean hands if you're trying to totally dodge a huge ERISA lien by kind of artificially putting it into a loss of consortium claim. You're not going to pass the smell test on unclean hands if you're doing that. So you could be open to an ERISA lawsuit trying to put a constructive trust on the amount going to the loss of consortium assignment to the spouse. So there's issues of comparative fault in subrogation. And so there's a case that I cite in the materials about a case that went to trial, and then they had a high-low, and whether or not the amount of comparative fault applies to a 287.150 settlement. So look at that case. It's a very unusual situation. I'm not going to go into detail, but if you're going to encounter that, it's just something to think about. All right. So let me keep on trucking on my slides here. Attorney's liens. So I could do a whole seminar on attorney's liens. So there's 2 attorney lien statutes, okay? When you assert an attorney's lien to an insurance company or anybody else, don't put the statute you're doing it on. You don't need to. You can, and if you do both statutes. One is a general lien, 44.130. One is 0.140 is a special one restricted to contingency fee contracts. So that is what I typically do. The statute requires the plaintiff provide the defense counsel or the insurance company notice of the lien. Send the lien letter at the start of the case to the defendant and or his insurer. That's when you want to do it. In the material, I have the whole statute set out. And it's a very strong lien. You know, lawyers always take care of themselves, right? So you know the lawyers who wrote that, it's arcanely written, but it is a very powerful statute, that attorney lien statute, the way it's written. Remember ethics rule 4-1.5F, and it's I don't know what conscientiously consider means, but if you have a fee dispute in a case, consider using the dispute resolution program. And basically, a lot of times this happens where the client switches lawyers, and let's say they come to me after, or they had a prior lawyer. Now it's my practice, you know, if someone calls me and has another lawyer, in my practice, I call the other lawyer and say, listen, you got a client going south on you. You may want to call them and make sure they're happy, that kind of stuff. And you try not to do that. But there's times when a client is just not going to get along with a lawyer. Or there are times when a lawyer has sat on a case for a long time and is just not crushing it like maybe they should. So anyway, try to work these liens out between us. You know, I think people do. I've always been successful in that. But if not, you can adjudicate the lawyer's lien too. And there's a lot of cases on this. Lawyers sometimes fight about fees and have done so historically. The Missouri Bar has a free fee dispute resolution program, which can work. An attorney is not restricted to any particular remedy for foreclosing his liens. He can do an independent lawsuit against that. He can also adjudicate it in the case at issue. An attorney lien is one in equity, not in law. So it's what benefit did that lawyer provide that client? It's the same equitable principles, quantum merit. It should, the second lawyer shouldn't be unjustly enriched, nor should the client. However, at the same time, if the prior lawyer has a duty of good faith and didn't have clean hands and latches and all that, then they're subject to that too. It's not an automatic, you get $250 an hour for all the time you can put in. It's, from my read of the cases, it's what value you added to the case. So there you go. And then I have some quotes on some of these unjust enrichment cases about and equitable principles, various factors, relationship, position, unclean hands, bad faith, that kind of stuff. And then the attorney seeking enforcement must prevent evidence that his work enriched the claim. The burden is squarely on the attorney's shoulders as he asserts rights to attorney's fees. Failure to provide reasonable value bestowed upon a plaintiff's case is fatal to any quantum merit claim he seeks. I've seen cases where one lawyer had another lawyer get up as an expert and say, I should get an X percentage of the thing. Sometimes it's based on hours. However, if you put a lot of hours into a case and you don't really advance the case, how is that benefiting the case? Concomitantly, I don't think courts, if you get an offer, let's say the case is a $100,000 case, the first lawyer gets an offer of 30 grand and then doesn't do anything for 3 years, and the client leaves and goes to another lawyer, files a suit and litigates it. The first lawyer who got 30 grand should not get, in my view, and I'm not a judge, I'm not deciding anything, but should get a third of 30 grand, or an automatic 10 grand. I've had lawyers tell me, well, I should get a third of what the offer was. Well, you know, the 30 grand was the easy money. Anybody could have gotten that. The client may be able to have gotten that direct if they hadn't gone to a lawyer, and those are examples. However, the reverse is true. I had a law firm do this to me one time. 6 weeks before a mediation, my client fired me and hired them after I already had an offer, after I think I'd already written the letter. And I don't have many clients leave me, and this one was a surprise. Well, I should have known it. This lawyer was, you know, it was one of those things. If you know, if you know that, you know, if you have problems early on with a client, you're gonna have problems later on with the case. It is what it is, right? That ain't gonna change. And sometimes I say to the clients, either I'm gonna disappoint you now, or I'm going to disappoint you 6 months from now. No matter what I do, I'm going to disappoint you. Anyway, he 86'd me shortly before a mediation. I had represented some other people in the same crash. We went and did a group mediation, and you know, I was aggravated about it, but I ended up settling my lien for a reduced amount. And yeah, they took me for some money, but I think that idea in the ethics rule that you should consciously consider resolving that is very important. You know, people don't like this fight about money, and they don't like it in courts. Sometimes you got to do it, but we try to avoid it as much as possible. So that is now let me look at my chat here. Oh, I got a lot to talk about here. Let me see. I'm going to talk for about 3 more minutes, and then I'm going to try to give a break, and then I'm going to try to get my friend Dave Crawford in here to do our next one. Let me see where we are here. Let me go backwards. Yeah, hey, Phil, unmute yourself and say what you want. If you're still on, say what you wanted to say on ERISA and LAWSA consortium.
Okay, great presentation, by the way, but there was a question on this long chat about consortium and wrongful death cases with ERISA liens.
Yep.
And
Yep.
that
What's the answer?
The Popaski case that I cite in my materials says if the plan doesn't identify the specific fund upon which it can collect on, it doesn't attach. So if you put it on consortium, services, companionship, they're probably not going to get paid because it's not medical expenses. You can adjudicate that in the approval of the wrongful death case and make them a party to get it barred.
Hey, I got a great question from Ben Goldenhurst. Ben, how are you, sir? Can a self-funded ERISA plan recover any wrongful death settlement proceeds? So we know a health insurer can, but can an ERISA plan?
It's the same thing with ERISA. If that plan language doesn't say it can, argue it doesn't apply because these are different beneficiaries. They aren't the one that incurred the bills. So don't try to get the bills, make it all for other things and it's legit.
And then remember too, the contract, the ERISA contract with the person who received the proceeds, that person's dead.
Correct.
And their debts should die with them. And remember too that a wrongful death statute isn't a common law claim. It's a creature solely of statute, and the legislature has the power to define the scope of that remedy and the scope of collateral attacks on the funds from that remedy. Where does a federal statutory, like where does Medicare and Medicaid Advantage come in when there are liens asserted under the statute? I don't understand that question, Bruce. Under Medicare, remember Medicare and Medicaid, they have what's called a super lien. You cannot get around it. You have to deal with Medicare and Medicaid. If there are if you're talking about the statute, the Missouri Lien Reduction Statute, that only applies to medical liens placed under that statute. Medicare and Medicaid and ERISA do not have liens under either the Illinois or the Missouri Lien Reduction Statutes. Oh, the other thing is that you'll see, Steve Bernstein, you lump non-perfected medical providers as lien holders in a motion to adjudicate liens. Not in a motion, Steve, but yes, I do in a letter. I very rarely, I probably argued maybe 2 or 3 motion to adjudicate liens in 29 years. But I do lump non-perfected medical providers as lien holders in everything. Even people who haven't asserted a lien, I just say they didn't. And Jay Umansky, you know, Jay sent me a private message, and thank you, Jay. I don't want to overspeak the surviving spouse issue. Remember that a surviving spouse may have an independent contractual obligation to the debt. So sometimes the policy is for both people. I've had clients, like they'll get you know, a bill collector will send them a letter and they'll sign off on it and guarantee it. Well, if that surviving spouse guaranteed it, she's on the hook for it. So let's remember that. Oh, and Debbie points out to be Medicare and Medicaid. So Medicare, the case that the Missouri Supreme Court case that I cited to you, and when I was talking about the medical liens not applying in death cases, that's true. But Medicare does apply in death cases. And ERISA may, as we've already talked about, and other things. So be careful about that. I don't want to speak too broadly. So Sally asked a great question, Sally Heller. If no formal lien, but the client signed a statement, he will pay providers out of the proceeds of the case. Well, that's a great question. So Sally asked, so let's say your client has health insurance. He goes, he gets care, but he also signed a contract that says he would pay out of the case, and he still owes a balance. Can they balance bill? Well, that's very interesting. So under Medicare, I have this fight in a current case. The regulations are all over the place on whether or not you can balance bill. I think I think, so you have two different contracts. Sally, I would take the position that they still have to take the amount of the insurance, that they can't get any more money, even if that, because the agreement to pay is no more of a right than any health insurance bill. So I'd get them to agree to that. I don't know of a case specifically on that, but I would take a strong line that they have to accept the amount of the insurance. Now, the reality is if the provider did a great benefit, did neck surgery, you know, these surgeons, you look, you see their amount they make on these surgeries. It's crazy. They make $2 grand and the facility makes 50 grand. It's crazy. They should get more money. Now, the reality is maybe you should pay that. And if you settle the case for a good amount of money, Sally, as I know you do, maybe you should pay that surgeon an extra 5 grand or something, because then they're going to be happy. Your clients may get continued care with that person after, et cetera, et cetera. So David asked, what can you do when the provider refuses to submit to medical insurance company in hopes of getting more money from the client? You reduce them like all the other people. You tell them that they have to do it. You have your client write a letter. You send it to, you have them send a letter saying, submit it to health insurance. You fight them. You adjudicate the lien as if they were a health insurance company. Go take a designee deposition of them, subpoena them, go take a depo and find out how much they would have made had they done it under insurance, and go find a motion to adjudicate lien. So here's the deal. All right, so we're running out of time. Everybody look at the Excel spreadsheets I sent earlier about how the details of the of how we reduce these liens. We had another question on the chat about explain the details of how you do it. And frankly, Illinois is just a little more complex, 40%, 40%, 10%, and it's just a different thing. We have a really good Excel spreadsheet I should have sent to everybody. If you missed it or you don't get it, email me back at gary@burgerlaw.com and we'll do it. Now I have 7 new messages. Eli Hadowski, who is really a smart lawyer. Eli, how are you? Medicare applies to Missouri wrongful death, but generally not in Illinois because its statute doesn't cite a claim for medical bills. Caveat that it can apply in circumstances involving a survivorship claim. Thank you. All right. I'm getting some private messages too from people. You know, a lot of lawyers know how to do this, and a lot of lawyers that are on this and other places always will share their knowledge for free. So let's do this. Let's always reach out to people, reach out to other people who know what they're doing. If you have these questions, call me or email me. I get lien reduction questions all the time. Thanks, Ben Goldenhirsch put Huey versus Meek into, he put a site in there for everybody. So look at this, the chat. Great question, Nancy. Are reimbursement agreements valid if made without payment or of new consideration? Yeah, that's great. Because, you know, none of these providers will treat you without that. And I think it's unfair for them that you can't get the gear. If you're going to, I don't think you can, if you're going to take the health insurance, you're limited to the health insurance, and your client's a third-party beneficiary of that. And I bet you that the health insurance company has contractual provisions that you can't go around that by having your client sign other contracts. But I would take a strong position with them and then fight it out. All right, so now we are right up to the 1 o'clock hour. If anybody wants to take a break, they can, but I'm going to find in my list here, I'm going to find my friend Dave Crawford, and I'm going to name him as a host so he can talk. Give me a minute here. So the next there we go, Dave. I'm gonna make Dave a co-host for this meeting. And then I'm gonna unmute you, Dave.
Great.
Hey, Dave, how you doing?
I'm doing well.
Thanks for joining us today, David.
Yeah, I'm sorry I'm late. Being a solo, I was dealing with a computer problem this morning.
I don't know anything about that, so
Yeah.
I did a argument to the Missouri Supreme Court about a month or so ago, and I know no one will ever listen. If you ever do listen, you'll hear me say at one point, "I can't find my timer," because I was on this video thing, and one of the screens had my timer. I couldn't find it, so I was like, I wonder if I'm going over my time. I don't want to make anybody mad.
Yeah.
Folks, Dave Crawford and I have been friends for a long time. Dave is an intellectual property lawyer. And you know what? I got to unpin myself. Unpin video. Dave's an intellectual property lawyer. He's worked with some big firms, but a number of years ago, he went out and on his own. He's the owner and operator of Crawford IP Law. Brilliant IP lawyer. Dave also happens to share a passion with helping other lawyers out who run into the problems that we all run into in life. I happen to be a former chairman for a number of years of MOLAP. Dave is a former chairman of the MOLAP committee, the Missouri Lawyers Assistance Committee. Dave and I have had training on helping lawyers through stress, addiction, all the problems that humans have, but lawyers particularly get attracted to. So Dave, without further ado, I'm going to share our PowerPoint. I'll let you start talking. I'm going to get the PowerPoint going. Dave, I'll let you take the lead, but you let me know when you want me to talk too. Is that cool?
Yeah, and actually, I had you up first with respect to the
of course you did. I knew
diligence.
That. Yeah. I have to say, I owe the debt of gratitude to Dave for the title of this presentation, which I love the book. Was that Gabriel Garcia Marquez who wrote that? Love in the Time of Cholera. But anyway, it's got in the bottom of one of my emails, it has one of the best first lines of any book, and that's one of the things that it's known for. So here's our slideshow presentation, and we're going to get this going here, and everybody should be able to see it. Love and lawyering in the time of the coronavirus. So this is by Dave and I. So let me start off then by talking about a little bit. So our ethics rules guide us about these issues that we all present with. And look, this corona stuff has been super stressful to people. We have a pandemic that's never happened before. People have to continue operating their legal practices. People have to adjust their legal practices to work from home. This is ever changing in terms of, the guidelines are changing so quickly. What do you do? And then we're worried about our business. Are we gonna lose business? How am I gonna make money? How am I adjusting my practice to this? I've done a lot of marketing CLAs and tried to educate myself about this as I've gone along. The clients are stressed. This is a high stress time. And it's tough to be diligent and communicate well in your cases if you're managing all this other stuff too. Remember, the two most oft reported ethics rules are diligence and communication. And it's like 80%. It's crazy if you ever look at the statistics. So keep the client informed about the matter. Promptly send them information. Keep touching them, even if you don't have to, even if you don't have anything to say, even if the thing is, listen, nothing's happened for the last 60 days because Corona hit, email them. There's a famous book called The 9-Word Email. You don't need to give people a book. You don't need to send people a 7-paragraph email saying, the clients love it when you just touch their case. Hey, I email people all the time. I say, hey, I want to let you know I'm working on your case today. They're like, that's great. You're working on my case. I love it. So let people know that. Be reasonable and diligent. My one lesson that I tell people in these from this is the way people work, I find, is that if you have a tough case, you're not going to work on that. If it's a hard liability case, what I tell people is take your hardest phone call, make your hardest phone call first in the day. Take the worst case you have and the toughest case, work on that first, because then then the rest of the day is easier. And what tends to happen, I've known other lawyers where I call it the dog with fleas corner. The case is a dog with fleas. It's going to stay that way, and it stays in a corner, and you don't work on it. You don't want to do that. You want to try to avoid that. So you judo that. You go into do the hardest case first. All right. So remember, there are 100 people on this Zoom call. The statistics say that 20 of you here, listen to me now, have addiction problems, okay? And in the ABA study says that the most recent one with the, who did that, Dave, with the ABA in 09?
That was up at Hazelton.
Hazelton, thank you. I mind blanked on that. It says that if you're a lawyer longer, you're more likely to have addiction problems because we have a high stress job. We're a self-selected population. So there's the Lawyers Assistance Committee, and there's also the Intervention Committee. I'm a member of the Intervention Committee. David, I apologize. Are you on the Intervention Committee?
Yeah, I am.
Yeah, thank you. So Dave and I are members of the Intervention Committee. We go help other lawyers or judges who have addiction problems. No one's going to raise their hand and say that they do in this meeting, nor would I ever ask them, because the second letter in AA is very important, anonymity. But if anybody ever has a problem with you or a partner or know someone who does, please reach out to Dave or I, and we are happy to assist. The more you give, the more you get in life. And that's one of the reasons why Dave and I do what we do and are talking to you now. And a lot of people are sitting there going, this doesn't apply to me. I know. I've only been, since the corona hit, I've only been day drinking for 3 months. I mean, give me a break, right? And honestly, that's what happens is you can lose your artificial constraints and your artificial boundaries. You don't have to come into work every day. Well, you know what? Maybe you can get high in the morning. So if you find yourself slipping or doing that, reach out to someone for help. It's the hardest phone call you'll ever make, but it's a life-changing phone call. So the bar has programs. We have the Lawyers Assistance Committee and the Lawyers Assistance Program. We have the Intervention Committee. Please remember that it is confidential. It is always confidential. If you ever reach out to somebody or reach out for your business partner or someone else and say so-and-so needs help, it is always confidential. We never talk to the OCDC about it. That is not the point. The rules segregate those. People will sit and drink for years and not reach out to MOLAP because they are sitting there going, oh man, the OCDC is going to get me. They're going to find out what I was doing in my trust account, blah, blah, blah. No, zero. That doesn't happen. And the reason why it doesn't happen is because that's the only way that people can get sober. And so there you go. This is one of the best written rules in your rule of Missouri, in your rules of civil procedure. Most people don't know it. Substance abusers contribute to incompetence and malpractice by lawyers and judges. Substance abusers neglect clients, violate rules of professional and judicial conduct, and commit crimes. You cannot get more direct or more accurate than that. It is true. If you ever talk to the OCDC people, when they find crimes or they find trust fund violations, the comorbidity of substance abuse is incredible because people take risks and make bad decisions. And so I'm already probably overemphasizing and over preaching and overtaking my time for what Dave is going to do, but I can't. It's so important that it is emphasized in our public rules.
Hey, Gary,
Yep.
Move ahead to slide 8.
Yep.
So, in addition to the alcoholism and drug abuse, alcohol abuse, there's so much stress in the industry. in young people, there's a tremendous amount of anxiety. In older people, there's a lot of stress or depression. And just as with the alcohol abuse, it's about the depression is about twice as much as the general population. And that again is from the Hazelden ABA study. But it's become important to have a, Gary?
Yes.
Move the slides ahead. Maybe it's on the wrong page or something.
Can you see it, Dave?
I can see the first page, but it hadn't been made into a slide presentation yet. So if you'll go to, see where it says slideshow at the top.
Oh, am I not sharing this correctly? Hold on.
That's what I'm thinking. But anyway, I was going to say, it's, you know, self-care, to take care of yourself with various techniques and to avoid the addiction problems have become critical, and so critical that even though you and I didn't learn anything about this in law school, they're actually starting to talk about these things in law school.
Dave,
And
how's that look? Can you see it now?
now hit enable editing, and then hit the slideshow. So, you know, you need this ability for self-care from your first day on the job all the way to the end of your career. And you need to be able to have some resilience so you can change with the times. And you have to do this with intentionality. If I think it's also important to know your warning signs before you go off the deep end, that that you're feeling stress. I tend to, and I think most people do, they get a little snippy with people, and they, you know, that always causes me to slow down and realize I need to back up. As Gary said, we can tolerate, as humans, we can tolerate predictable, moderate, controllable stress. But the stress that we're experiencing now with the COVID is unpredictable, extreme, and it's going to be prolonged. It's increased our vulnerability to long-term vulnerability to disease, behavioral health disorders, difficulty functioning in general, challenges our ability to cope. And so, and the other thing is that the way to combat that is through having a certain amount of resiliency. And resiliency, we can actually improve our opportunity to be resilient. And there's various tech. That's it. Now,
thank you. I'm sorry.
That's okay. Go to.
I had all my
16.
rules. I have all my rules here. I didn't realize that. So
That's cool.
Cool, man.
So yeah, go on to 16, slide 16, almost. Right there, that's cool. So there's a bunch of different ways to work on your self-care and for your well-being. And I've studied these through periods of time because yeah, I've found them helpful to reduce my stress. And to be honest, I suffered from depression for a number of years, and I got to stay on top of it because it's not healthy when you're severely depressed, and it's hard to get out of bed, and hard to pick up the phone to call anyone. So it's really important for your diligence to be able to do this. We're, as it says there, we're hardwired to be, we need relationships. And so you should build and maintain your relationships. And in certain societies, they shun you if they want to discipline you or throw you out of the community. They'll shun you, and it's extremely effective because of our hardwiring for relationships. It's critical for happiness. Physical touch then again releases the oxytocin, which is very good for your health. And then when you're choosing your connections, you should take some effort make some effort to make sure that they're positive people. If negative people, sometimes you got to help your friends out when they're being negative, but at some point, if someone's always negative, it's best to prune them from your tree of friends because they're it's contagious. Go on to the next one, Gary. The part of the deal with lawyers is that it's very lonely. We're in probably one of the lonelier professions. It's even if you're in a large firm these days, you go to the office, you close your door, and you work alone, and you may get up and to go to lunch, but that's about it. And so it can be a very lonely existence. And loneliness is linked to a lowering of that resilience to stress. It's also shown to be to decreased happiness, sleep dysfunction, impaired immune system. And the more connections we actually have a longer life, improved immune system, reduced depression and anxiety, overall better functioning and well-being, reduced cardiovascular disease, reduced perceptions of pain and threat. So it's important that we build these connections. Go on to 20. Yeah, benefits. It's also important to cultivate positive emotions, and some of us are less positive than others, and so those people have to, like myself, have to work extra hard to have a positive attitude, particularly in these times. And the people that study and improve their positive emotions have a longer life, a better satisfaction with their life, less anxiety and depression. And so yes, exactly. You want to actively cultivate the positive emotions to counterbalance the negative ones. You see, I've got the one negative. It takes 5 positive emotions, 5 positive occurrences to counterbalance the negative ones. And it's just sort of like with criticism, you try to give, when you're giving constructive criticism or when you're talking to your spouse, 5 positive things to every negative thing. Otherwise, you're part of the problem. One of the things that they talk about in recovery is the attitude of gratitude. And they have done studies where they take people who win the lottery, and immediately following winning the lottery, they are very elated and happy. And but that falls away fairly quickly, as opposed to people who gratitude journal. And this is one of there's a couple really key techniques to improve your emotional health, and gratitude journaling is one of them. And basically what we do is to do this, you might have a certain notebook. You might choose the number of items on the list that you're going to do daily. But the best, you want to pick maybe 3 to start out, because it can be hard if you're not in a positive place. But jot down 3 things in the morning that you're grateful for, or 5 things that you're grateful for, and that eventually it's important. The kinesthetic learning of writing it down physically is really really beneficial as well. And we found that over time, as people ruminate on these positive things, that they feel less isolated and have more optimism and joy and less self-blame. And it's you know, I used to think this is crazy, but it actually works, and it's one of the best techniques for improving your emotional well-being. For me, when I do the gratefulness gratitude journals, is after meditation, which I also do in the morning. And Gary, you can advance that a couple. But for a good technique for meditation is, well, first of all, I use mindfulness, and it's a state of mind to be present and aware of your surroundings, not stuck in the past or thinking about the future. You know, if we ruminate about the past, that's not good. And if we're constantly worrying about things that may never occur, that's not good. So to just look at the here and now is very powerful. Some benefits, and you can move it on. You know, less stress, less reactivity, less feeling of overwhelming. It increases your concentration. It reduces the distractions. The overall happiness, empathy for your clients, ethical boundaries, everything improves really with mindfulness. And at first, when I started doing mindfulness, when I first started doing mindfulness, I thought this is some kind of hocus pocus, but it really works. And there are various places where you can learn about mindfulness.
Where would someone go to learn about this, Dave?
Well, there's the Mindfulness Law Society, or Mindfulness in Law Society. There's a number of great books about it. There is an article just today in the New York Times about meditation, and there's meditation apps that you can use. This Mindfulness in Law Society is where I got a lot of the materials for this presentation, and that includes Bree Buchanan. If you're into this area with the ABA, you've met her. She used to be with the Lawyers Assistance Program of Texas, and now is doing some private practice stuff. She's phenomenal. And then here in Missouri, at the University of Missouri, we have a professor who's actually a big part of this Mindfulness in Law Society. The technique for me is I pick an object of concentration, typically one of the senses, and in particular breath, and I'll sit
you mean not focus on the case that I lost?
Right, exactly. Yeah, that's not healthy. That rumination's not the healthiness. But you know, sit in a not in a bright room, sit in a quiet place. You just sit comfortably, close your eyes, and taking the breath as the point of concentration. You breathe normally, and usually I pick wherever the breath is hitting me that day. And if you guys can take a minute, let's try this, if you will, with me. If you'll close your eyes and breathe normally and concentrate on your breath. And the area where you're breathing, it might be the rise and fall of the abdomen. It might be the expansion of the lungs. It might be, for me today, it's the back of my throat. And so it just consider that feeling, just concentrate on it. At some point, because we have monkey minds, you're going to realize that your mind has wandered. And the point is to acknowledge that something has distracted you, and to bring your attention back to the object of concentration, and without any judgment or self-criticism, because it doesn't matter who you are. The Dalai Lama is he drifts too, like all of us. This has been found to be beneficial for for concentration and for not ruminating on the past, or and we can stop now, but not ruminating on the past, not thinking about the future, but staying in the now, and particularly with the current situation. You know, we can be worried about financial insecurity in the future. Where's my next client coming from? Is the phone, those first 2 weeks that we were all shut down, you know, it seemed like, is my phone going to ring, was my biggest concern. And by being able to, by practicing to refocus my mind on the here and now, and not worry about the phone isn't going to ring ever again, you know, it helps you have a better stability. Another type of practice that sometimes we'll do is start out the same, take a few breaths to, you know, relax, and then I start at the feet, and I feel the sensation in my feet, on the soles of my feet, and even though I'm wearing a suit, I'm actually barefoot on carpet, so I can feel the Berber under my feet. And then I consider that for a while, you know, and then I might go to the tops of my feet and on up my legs, and and consider everything along the way. My seat bones, I can feel it. I can feel on my thighs the texture of the seat I'm in, and so on. Going up your trunk, up, and you progress slowly, and this is maybe an easier place to start for some, because it's more active. You're considering, it's not a rhythmic study, but it's concentrating, but it's more of a dynamic practice, but it's the same sort of, it works just the same way. The other thing that interesting about this, and I find, you know, 20 minutes is perfect for mindfulness, but they have done studies and have shown that 6 minutes works too. And so if you don't have time in your day to do 20 minutes, then try 6 minutes. 1/10 of an hour. You know, we live our lives, well, those of us that aren't personal injury lawyers anyway, live our life in 6-minute intervals. And it can be quite beneficial. One of the other things is physical wellness. You know, it's amazing. Just like your mother told you, you know, the exercise works, can work in many of the same ways to reduce your stress and all that. You got to eat well, and that means not eating a load of stuff that, you know, which is what I've been doing during the pandemic, is eating too much, and actually eating too much of the wrong stuff. And again, that there's that mind-body connection that if you're putting a lot of bad stuff in, it can cause a lot of stress, cause you being unable to deal with the stress, and with the heightened stress, that's a problem. Next big one, and this is a huge one, is the sleep. And you know, we use chronic sleep deprivation if we're trying to bend someone's mind, and the reason why it's so effective is it really slows down it really makes gives you a cognitive impairment. People are less able to deal with stress, increases heart attacks, blood pressure, strokes. This is greater burnout. The one I highlighted there, the highest predictive value for depression. So if you're not getting sleep, you have the ability to, or you have a higher chance of becoming depressed. One other thing I wanted to talk about while I'm dealing with that, you know, women report a higher incidence of depression than men, and that's probably not because women are inherently more depressed than men. It's because women know when they're feeling down, and men may not be able to, may not have those, the ability to feel the same things. And so a lot of times what happens is men, you know, they get to sort of the angry man scenario where they're, you know, snapping at their spouse or their assistant or whatever, and they become really mean. Well, the truth is they're depressed, and they could use some help. The next part is yours, Gary, if you'd like to take it.
Yeah. So we have a section here on ethics charges. So if you do get, if you have an ethics complaint against you, what do you do? And I know we're jumping a little bit. First of all, I want to say, Dave, that was very beneficial. I started transcendental meditation in college, I remember. And I remember, like, when I was running in high school and stuff, my cross-country coach would do this relaxation technique where we would think about different parts of our body and relax our body. So, and if you ever, you know, take a minute to relax yourself, figure out what part of where you carry your stress, where you stress. You take a minute to be mindful. And I mean, now it's mindfulness, but some of this stuff has been going back a long time. So, you know, usually in ethics stuff, we talk about ethics rules and this and that, but I like that we're able to talk about this, and lawyers are starting to think about this mindfulness and managing our stress. The snapping part, isn't the snapping part too stress, not just depression?
It can be. I mean, I'm not a psychiatrist, but you know, being biting and angry all the time with men can be depression.
So let's say you do get an ethics charge or a complaint against you. What do you do? First of all, de-stress. Second of all, Do you hire an ethics lawyer, handle it on your own? You're going to get a letter from Mr. Pratzel talking about citing rules, ethics rules, and things that you've done. You want to draft a non-confrontational response to his letter. Look and analyze it. Did you violate an ethics rule? Did you not communicate? Were you not diligent? Is the client complaining? Is the other lawyer complaining about appropriate action that you took or inappropriate? If you have done something wrong and you do have a concern about violating an ethics rule, that's when you want to consult with an ethics lawyer. And there's a lot of good ones out there. Or have friends. I served on the ethics panel for a decade or whatever, getting complaints. You know, there's a lot of lawyers out around that know a lot about ethics, even if they're not don't hold themselves out as ethics counsel, official ethics counsel. There's a number of ethics counsel that in the area that talk, and my experience is that other practicing lawyers who have knowledge of ethics, as well as the people who are in the business, they'll talk to you for free. You'll run a fax by and they'll say, yeah, they'll say, you know, write the letter yourself, don't worry about it, or you got something to worry about, you should come talk to me, that kind of stuff. Remember, your ticket, your license is very important. It's how you're making your money. It's your profession. So take them seriously. So the way the process works is that the complaint goes to a regional disciplinary commission that's going to review it, and they can either dismiss, recommend it to be dismissed. They can recommend an admonition, or if it's really bad, they can send it straight to the Missouri Supreme Court. They'll also have a lawyer with them, a special representative they're called, who also acts as kind of the lawyer for the commission that can also recommend it go straight to the Supreme Court, and also has a lot of experience in those matters. The purpose of discipline is not to punish the attorney, but protect the public and maintain the integrity of the profession. So that's some things to do if you get an ethics charge. Sorry, I went ahead, go back.
I'm back.
Sorry, I got it. I'm get it now.
I live in the present.
Yeah, that's right. Could be conscious and present in all things. Don't project and don't live in the past.
Yeah.
Right.
You know, earlier, I'm sorry, Gary. Is that okay? The earlier I was talking about connections and building relationships, and you know, I got to say, I've got 2 or 3 guys that when we're not in pandemic, I meet for a breakfast, you know, once a week or so. Usually just me and one other person. Gary, I know, you know, we meet for lunch on some occasions, and that's part of my my way to build a connection. And when you find someone that you can relate to and you can be upfront with, it's nice to be able to find someone that you're close enough to that you can feel you can tell them anything, and maybe that's your spouse. But one of the things we want to do is to show, one of the things that we can do is to show vulnerability, ask for help when we need it. You know, as lawyers, we're problem solvers. We don't lay our problems on our clients. You know, we generally can't talk about what we're doing, at least in you know, as a patent lawyer. I don't talk about what I'm doing until a couple years after it, if I talk about it then. And that's the ability to have a special connection and to show the vulnerability, the courage to admit that you need help is one of the benefits of using your relationship.
And it worked. It's tough to do as a lawyer, Dave, because you know, you're supposed to be, I win everything, I whoop everybody, but I've never made a mistake. I've never messed anything up. I've never taken a bad depo or whatever on a litigation side. And that's not true. I know what I know because I've messed it up before.
Yeah.
But you don't want to walk around saying that you're not perfect. And and, you know, especially in social media and all this, and, you know, you're trying to get business. So it is true having, you know, I have a bunch of lawyers or friends, you're one, I have a lot of other friends, and I'll sit there and I'll go, look, I got this. What do I do in this situation? You know, because, you know, there's also this saying that it was some, you know, you ever hear the saying, your first thought is your worst thought. So sometimes your go-to thought, maybe you shouldn't be as combative. Maybe you shouldn't yell at that client. The joke is, you know, write that letter and then put it away for a day or so, or the email, save it and then do it. So having that connection of lawyers who are people that they're not going to judge you. They're going to listen to your crap. And then they're going to say, listen, calm down. Why don't you do this? And then the other thing pedagogically, or we learn in law school, is I figure out the best tactics to do in cases by talking to other lawyers and stuff. You see, I get this idea. Well, what about this? Oh yeah, I never thought about that. So having that network of people, it's hard to find the time to do it though.
Well, you know, I meet with 3 other lawyers once a week. We have a little 12-week year group that we've been doing for, I guess it's coming up on a year. And it's fantastic because we talk about our goals and whether we met them that week and all that. But we often have those types of conversations you were talking about. And as we do it at 7 a.m. So, you know, we find time at 7 a.m. to squeeze that in, and it's so beneficial.
So let's just talk a little bit about ethics. Let me just go through real quick and we'll get, and you have more slides, right?
Oh yeah,
good.
A few.
Right, so on 8.3, do you have to turn someone in only if it becomes a question of their honesty, trustworthiness, or fitness as a lawyer? It's not an automatic thing. But if you know someone who has committed that, and judges too, sometimes judges have issues, and you need to. There's the ethics commission for judges too, and 8.3 does not require you disclose information if someone is going into the lawyer's assistance program. If someone does have an ethics charge associated with substance abuse issues, then there's a separate track and separate ways that the OCDC handles that as well. Here's a slide that I did on if you surrender your license. The answer is don't surrender your license, because if you do it, if you surrender your license for any reason, you're disbarred and you must seek reinstatement in accordance with the rules. You got to go retake the test or get in. So avoid sticky ethical situations, including federal crimes, duh. But the other thing is, if you're heading into sticky ethics territory, note it right away. Address it head on, avoid it, get counsel there. Hey, this might be a problem. I might have a conflict. I might have this or that. What do I do with this money in my trust fund? Deal with it head on and early. Don't bear. It's kind of like, you know, this is my joke for Dave and I's presentation on the emotional side. Don't do what I do with my emotions. Shove them down deep and keep trampling on them so no one knows about them, like every man is supposed to do, right? No, you know, like the ethics stuff, share it, talk about it, throw it out there, because you ain't the first one who's had this issue come up. That's why we have these rules. These paths have been trod before. So speaking of that, good segue. Dave, let's talk a little bit about showing vulnerability.
Yeah, and I was talking about this, not realizing what slide we were on, but
no, you knew it. You were just foreshadowing.
Yeah, forge ahead. So I'll admit my faults, but the showing vulnerability with those special people in your life is very beneficial. You know, some say that a problem shared is a problem halved, you know, cut in half. So, and to a certain extent it is. And if you don't have someone, going back to that journaling, that's another great technique to get it off your chest. And in some ways it can be very, very beneficial to you. Next slide. Yeah. So
so showing vulnerability, is a real tactic being used by a lot of trial lawyers now too. When you walk into when you're like your opening statement, or you can say things like, folks, I was really worried about this issue in the case, or in voir dire. Here's the issue. Let's talk about it. Let's not hide it. Let's bring it out right in front and center. Defense lawyers do it great. Plaintiffs lawyers do it great. If you double down on your vulnerabilities in your, these are personal. I get the message. Dave, is personal too, but these transcends to everything in the way you practice and the way you do it. And that's the way you talk to clients. It doesn't matter whether you're an IP lawyer or me. You say, listen, here's the good parts about your case. Here's what your vulnerabilities are. So let's get it on the table and let's have a real conversation about the real issues for your clients as well. Sorry, go ahead to your.
As you know, you don't have to have the answer to everything. And, it's sort of a way of showing vulnerability. I don't know what the answer is to that. I've got to do, I've got to look into it, is frequently a great answer.
And one of the things that clients need to be taught is that the lawyer isn't the answer for everything. There are things beyond the lawyer and their control. I didn't create these facts, or, the law is what it is. It's going to protect you some, but it ain't going to protect you here. It is what it is. And then that way you don't have clients blaming you down the road for something that you didn't disclose, right?
That's right. So moving on, the barriers to help seeking, part of the problem with lawyers is sort of what we've been talking about. You have to, you don't want to show your faults. You're there to help people. And you think people might not, you may lose clients or something. Well, my experience has been when I show my human side, for example, pointing out that I had been depressed. A year or so before that, I'd had cancer, and some lawyers, said, "Well, why would you tell someone that?" And it's not for sympathy. It's just for me. It's just part of being human, and that had. I think that not only showing the vulnerability, but to let people know that that you have a problem, need the help, and get the help that you need before it becomes even a bigger problem, and you're talking to OCDC. Now, we had talked about on the next slide the Missouri Lawyers Assistance Program, and there's as Gary pointed out, it's free and confidential, and it really is free and confidential, and they do a good job. If you're in a larger firm or corporation, of course your EAP, and now behavioral health coverage is part of many insurances. Find yourself a personal therapist. I don't think I would have ever got into therapy if my wife hadn't suggested it. And I'm still in therapy. I love it. It's very helpful to me, and it's nice to pay someone to listen to you. But if you need to help finding a good therapist, if you go to Psychology Today, Google search, they have lists of therapists. If you're in Illinois or any other state, I think 48 out of the 50 states, searching COLAP and mental health resources. And, I sometimes get calls from MOLAP to help someone locally, and they've called MOLAP because they're in, Connecticut or something, and they need help locally. They call MOLAP. MOLAP puts them in touch with me for whatever that might be, and and I help them out. Suicide prevention, part of the deal with all this mental health stuff is I think every one of us knows one or more lawyers who've committed suicide. like all the bad stuff, we do that at about twice the rate too. And it's sort of epidemic, among professionals, doctors and dentists and all that. Lawyers are right up there. And so this self-care that we've been talking about, it is so very important. And I think, if you need the help, reach out to someone and get the help. If you see someone who needs the help, no one ever committed suicide because you said, "Are you okay? Are you depressed?" and showed people concern. If someone jokes about suicide, I always take it seriously. I've had far too many lawyer friends who aren't with us anymore because they had mental health problems that they concealed. We talked about on the next slide. Here's again, some more about MOLAP and its confidential counseling, the crisis intervention. It will deal with law students. It deals with families of lawyers sometimes, and it's a very worthy resource, and too often not used or underused. And then lastly, I think was the therapy section, and that's about it. The many of us have. If you haven't been with haven't used a therapist, they provide a good sounding board, just like Gary was talking about having good close friends. Sometimes therapists can do that when our own friends would not tell us, "Oh, that's a bad idea." So I think that's worthwhile. Setting goals, using them almost as a life coach, and it can they can help you learn how to talk to other people in a way that's positive to the relationship. The marriage counseling, it works. I thought it was a bunch of mumbo jumbo, like a lot of things, and they really do help. And we've learned so much in the last 20 or 30 years in terms of psychology and therapy and all that. That's all of the written materials I had. I hope there's a couple of questions, and if not, I don't know that anyone will complain. Gary?
No, the comments here are more about someone talking about transcendental meditation, which I mentioned too. Someone else talked about that, using gratitude to navigate challenging times. I see Phil thanked everybody. Thanks, Phil. Whenever I find myself, Dave, getting squirrely or getting too critical or getting in phases of that, I always, because I get busy, I get busy and I forget to, just like like before Corona, I'd try to work out or run or ride, and then I get busy and I'm like, shoot, I haven't run or ridden or anything for 2 weeks. Right. You got to work all those muscles back because I'm old now and stuff. But the same thing true, and I just don't think of my mental health the same way. I'm not wired to do it. And so I have to make myself, because every time when I start getting be a jerk or something like that, I always, if I take the time to step back, I'm like, you know what? I'm not taking care of myself. Yeah. I'm not de-stressing. I'm not focusing on my gratitude. I'm not focusing on this and that. And I'm almost, shit, I'm 53. I'm tired of learning the same lesson, but I still have to, where I'm human. We all have to, we all have to sit and remind ourselves of these things. So literally listening to you tell this thing, Dave, I was sitting there going, you know what? To be honest, I haven't been meditating lately. And I haven't been taking the time out to do some of these things. And I haven't done a gratitude list lately. And I haven't sat and called guys like you and just shot the breeze and said, hey man, how's Corona treating you? I get away from it. I get so busy with my own life, I forget to take care of this stuff.
And we all do, I think. I mean, I know people that have been practicing meditation for years and years and years, but for me, it comes and goes. And when things are great, I may forget about it until, like I say, I'm very cognizant of what my what the signals are that I'm not doing the things I should be doing because, you know, I'm snippy or whatever. And by being conscious of it, you know, it gives us the ability to slow down. The other thing is if you're not exercising and eating right and getting enough sleep and doing the gratitude and, you know, the gratitude journals and the meditation, if you're not doing all of them, don't beat yourself up about it. We're human, and that's not the point of you know, recognizing these things are good for you. The point is to take on, you know, if you're not in a good place, take on something new. For example, I think a great place to start is getting enough sleep. You know, I think it's maybe prime directive number one, and then work on some of the other things. But, you know, this month, you know, get that as a good habit, and then make a little micro improvement next month by doing another good thing for yourself, and it just builds on itself, and ultimately it can change you in tremendous ways.
Thanks a lot, Dave, for the great lessons and the great reminders, which are a little bit of both. Thanks a lot for doing this presentation with me. Phil, thanks a lot for doing the presentation as well. Thank you, everybody, for attending. I really appreciate it. I really enjoyed this. I've learned some things, and I really appreciate it. Remember, we have an online poll for this. We had some questions to ask. We put something together. If anybody can do that, we'd appreciate it. Remember to support legal services. And, you know, one of the things, the more as David was saying, the more you give, the more you get. You get yourself out of your own head. And I have never found that not to be true. I mean, every time I go take something on for someone else, I'm like, you know what, that's what I got to be doing in life. Life is too short not to raise all ships and help other people. Hopefully we've done a little bit of that with some of this CLE stuff today. So everybody spread meditation, calmness. Let's help our fellow professionals and keep on fighting through these strange times we are, both politically as well as pandemically. Thank you, everybody.
Thank you.
Take care, all. Thanks for the time.
Bye. Thanks, everybody.